Justice Lori Earle.
Justice Leslie Lopez.
Justice Hart.
And this is the matter of Not So Innocent versus the United States of America. There are 3 issues before the court today. The issues are whether or not Not So Innocent should be treated as having relinquished her citizenship in the United States. The second issue is if Ms. Innocent is found to be a U.S. citizen, do the facts as disclosed in the record justify her prosecution for treason? And thirdly, if Ms. Innocent is found to have relinquished her U.S. citizenship, should she be held as an unlawful enemy combatant, subject to trial before a military tribunal without further supervision by the civilian judicial system? Ready? All right, the appellants, you may begin.
Madam Chief Justice, and may it please the court, my name is Janice Pig, and I'm here to show that the appellant, Not So Innocent, should be treated as a U.S. citizen, and no actions by her relinquish her citizenship. My co-counsel, Jasmine Kangura, will argue that she did not commit acts of treason, and thus Travis Moore will address why Ms. Innocent should not be treated as an enemy combatant. Leanne Couch will rebut. The law in the United States provides citizenship by birth or voluntary naturalization, and thus includes Not So Innocent, who is a native-born American citizen. According to the Immigration and Nationality Act, citizenship can be lost only if one performs certain acts voluntarily with the intentions of relinquishing their citizenship.
Let me interrupt you. Under the Calquita case, isn't the court to look at whether Ms. Innocent treated her citizenship as a fair weather type of citizenship, where she just sort of cavalierly used it to go to college, but otherwise didn't really have a vested type of interest to further her allegiance to the United States?
Yes, Your Honor. But when, in the case of Ms. Innocent, when she came to the United States to further her education, she showed that she did exercise her rights as an American citizen. And 2 ways dictated in the Act relevant to this case include paragraph 2, taking an oath or formal declaration of allegiance in a foreign state after having attained the age of 18 years, and paragraph 7, committing any act of treason against or attempting by force to overthrow or bearing arms against the United States. Therefore, it is important to look at the reason and intent behind one's actions. For example, in Calquita v. U.S., Mr. Calquita tried to renounce his citizenship by explaining his actions acted in the way opposed to being a U.S. citizen. Nevertheless, the court held that he retained his citizenship despite Mr. Calquita accepting and serving the duties of employment under the government of a foreign state and making an affirmation of formal declaration of allegiance to Japan, which opposes the Nationality Act of 1940. In any case, if Mr. Calquita was determined to still be an American citizen, seeing how much less Ms. Innocent did and how her actions indicated her intentions less than Mr. Calquita, it is only reasonable to see that Ms. Innocent retained her citizenship.
Counsel, I'm sorry, let me interrupt you again. Under the health case, shouldn't the court look to whether, not look at it, the person's intent, but rather look at did those acts actually help the enemy?
Yes, Your Honor. It is important to look at how her acts, if they were found treasonable, to see if they aided the enemy, which my co-counsel Jasmine Kangura will address, which addresses treason.
Let me ask you to pause for a minute also. I assume you're inferring or referencing the fact that Ms. Innocent took an oath of allegiance to the Indonesian government. And my question is, do we need to focus on whether or not that was a voluntary act or was it an act required by the government at the time?
Yes, Your Honor. It is extremely important to take into consideration her intent behind her actions while signing that oath. Though born in America, Not So Innocent's childhood was spent in Indonesia where her parents lived. At the age of 18, she signed a standard loyalty oath to Indonesia as required. This signing alone cannot cause her to lose her citizenship, as the purposeful intent to relinquish her American citizenship must be there as well. Upon closer examination, it seems that Nassau's actions were not quite so voluntary. It was obligatory. In order for her father to retain his job, who she was still financially dependent upon, a colleague despite reaching the age of 18.
Counsel, could she still have come back to the United States or have chosen not to take on the citizenship at the time?
Yes, she could have, but as an 18-year-old who was still financially dependent on her father, with her family's financial welfare upon her shoulders, she did not have much of a choice when it came to signing the form.
How was her financial welfare of her family upon her shoulders?
When her father's job was, whether her father could keep his job or not, was based on if she signed that standard loyalty form to Indonesia. When she signed this form, dual citizenship is permissible as stated in Courthouse v. United States, which states that the concept of dual citizenship recognizes that a person may have and exercise rights of a nationality in two countries and be subject to the responsibilities of both. Thus, Nassau was simply fulfilling her responsibilities as an Indonesian citizen by signing the compulsory standardized form, and had no particular intent to renounce the U.S. citizenship, especially since she invoked her citizenship 2 years later when she traveled back to America. Unless Indonesia was an enemy of the United States, signing the form cannot be considered aiding or abetting with the enemy. Thus, though Ms. Innocent did indeed sign the customary loyalty oath, her actions were neither voluntary nor done with the intent of relinquishing her U.S. citizenship. There is also another way to lose one's citizenship, and in paragraph 7, in the Immigration and Nationality Act, states that any voluntary treasonable act will result in a loss of citizenship. In Kawahita versus the United States, Mr. Kawahita, also a native born citizen, committed an act of treason when he gave aid and comfort to the enemy with intent to betray, which was not in his job description when he treated American prisoners of war cruelly, which displayed his intent to betray. Yet the court ruled that Mr. Kawahita retained citizenship. Contrast these facts with this case, and Ms. Innocent did not participate in any of the above acts. Instead, she actually came to the United States and exercised her citizenship through living here, going to school here, and even adapting to the culture in America. If Mr. Kawahita was still a citizen, despite his actions and intent, Ms. Innocent was definitely one as well, as she did nothing to indicate otherwise. Therefore, I urge this court to see that Ms. Innocent did not relinquish her citizenship, and accordingly should be treated as an American. And now my co-counsel, Jasmine Kagura, will further explain why Ms. Innocent did not commit any acts of treason.
Let me ask you, Ms. Moon, before you move on, whether or not the fact that Ms. Innocent told immigration that she had no specific loyalty to the United States, she's just taking advantage of her legal status to become a U.S. citizen. How does that reconcile with your opinion that she did not relinquish her citizenship?
Your Honor, while that is true that she did state that she had no particular loyalty, when she was raised in Indonesia, it was only natural to feel more loyal to one country than the other. But the level of loyalty felt by a person does not indicate whether they are considered a citizen or not. As an American, we have the right to have different beliefs, and it is her right to hold certain beliefs, certain political beliefs, and in her case, no particular political or apolitical views.
Madam Chief Justice, and may it please the court, my name is Jasmine Kagura, and I'm here to show that Ms. Innocent has not committed treason. First of all, treason is any act which gives aid or comfort to the enemy. Ms. Innocent was born in New York, but she lived most of her life in Indonesia for 20 years. So when she came back, she met Mr. Haddison, who happened to be a Muslim. The country which she came from, and then she lived there for 20 years, that country was inhabited largely by Muslims. So when she first met Mr. Haddison, there was barely any difference. It was just natural to her to have a boyfriend who happened to be a Muslim. Later on, she became her girlfriend. Now, for a relationship to be successful, a person has to have trust. And soon, Mr. Haddison told Ms. Innocent to buy 2 parts for his RAM radio from a local electronics shop. She went and bought the 2 parts, having trust in him again. For a relationship, there's supposed to be trust, and she trusted him and bought the 2 parts and gave it to him.
But do you abandon your common sense in order to blindly trust another person, even if you have a relationship with them?
Your Honor, here, she is an educated person, because we know that because she came here all the way from Indonesia just to earn a college degree. And this is her, everyone has a right to have their own opinion, and In her case, her opinion was that her boyfriend just wanted the 2 parts for the ham radio. She was not aware of his intentions.
But didn't the Radio Shack employee inform her that these parts could not possibly be put onto a radio?
Yes, Your Honor. Here, when a person, she trusted Mr. Addison more than the employee, which happened to be a stranger. It is human nature to trust someone you're closer to than to just listen to a person such as an electronic store who happens to be a stranger.
Even where that person has some expertise in the particular area, the item that's being purchased?
Your Honor, here she happened to choose between her employee and her boyfriend, and then she trusted her employee more because she trusted her boyfriend more because she had a relationship with him, a girlfriend. And for a relationship to be successful, there needs to be trust in between. So therefore, she trusted him instead.
Well, didn't she also have a friend with her on the trip who would warn her of the same thing?
Yes, Your Honor. She did happen to have a friend who did warn her, but then she did not consider her friend's advice because she rather trusted her boyfriend. She had that deep trust in him. So Mr. Addison told Ms. Innocent to buy the 2 parts because he didn't want to face a racial attack. So this is quite reasonable for a girlfriend to protect her boyfriend and be naturally devoted to him. So
I'm sorry to interrupt, but under the cases that we were looking at and discussing, are we allowed to look into her intent to just go along with her boyfriend's desires versus just having a very objective view of did these acts actually help an enemy of the United States?
Your Honor, here she was not aware of the real intention of the 2 parts. She was told that those 2 parts were going to be used for the ham radio. And intention is shown by actions. And here she was not told that those 2 parts were going to be used in the ham radio. There's no evidence as such. And even in the Hop case, the father supported his son, and he did it out of love and he knew what he was going to do. He knew that his son was committing a treasonable act. But here, she was also in love with her boyfriend, but she did not know why these 2 parts were being used for.
So how should we distinguish the acts in Hop, where the father, for example, just rented a room for his son, here with Ms. Innocent just purchasing a couple of otherwise benign items?
There in the Hop case, he showed his intentions by supporting his son, committing treasonable acts. He knew that his son was committing those acts, and he supported him. But here, she did not know that her boyfriend was aligned with the Al-Qaeda organization, and she unknowingly gave the 2 parts to him, and she was not aware of it, so therefore she did not have intentions of building the dirty wall with him.
But might it be said that she had some notice of her boyfriend's intentions by the fact that she knew that he had some rather radical views, political views, and she had some at least notice by her friend and the sales clerk that his reason for purchasing these items were suspicious? Doesn't that place her on notice that something's not right here?
Yes, Your Honor. According to the First Amendment, an individual can have any type of views. So therefore, Mr. Addison having radical views is not necessarily means that he is a terrorist, because in our Constitution it stated that, and she was just merely following the human rights which are present here. And every individual has their own opinion, and here she, rather than trusting the employee, she trusted her boyfriend instead. And she has her reason because she was more intimate to her boyfriend. And it is not fair to just jump from a reasonable jump that it's not a ham radio, it's going to be used for a dirty bomb. So she just bought the 2 parts and gave it to her boyfriend. And even Justice Murphy has stated in the Hop case that every act is not an act of treason, especially if it's out of the well of human kindness. She gives those 2 parts as a natural devotion to her boyfriend. Therefore, it was out of kindness, and it was not a treasonable act. And her acts do not show intention that she is committing any act which promote the cause of the enemy. Comparing to the Kawakita case, this is nothing. He said that he wished all the Americans were dead. He also promoted the cause of the enemy by by hitting them and pushing the American prisoners of war who were ill, who were not healthy, and who were having dizzy spells. He made them work for the production of Japan, and that is promoting the cause of the enemy. He even did horrible acts such as he made them kneel on the bamboo sticks, and then he made them carry a full bucket of water on their heads. So therefore, he promoted the cause of the enemy. And here, Ms. Innocent, she just bought the 2 parts without any knowledge where those 2 parts were going to be used for, and gave it to her boyfriend. And in the Hawk case, there is a difference. He bought the 2 parts and gave it to the father supported his son, and he knew that his son was committing treasonable acts. But here, she did not know of her boyfriend's intention. So an individual who does not know the actual reality, who does not have knowledge, should not be tried for treason. She was not aware of the actual reason why the 2 parts were being used for. She was told that those were only being used for the hand radio. Therefore, I urge the court to rule that Ms. Innocent should not be tried for treason. And now my co-counsel, Schaber, will show that she is not an enemy combatant. Thank you.
Madam Chief Justice, may it please the court, my name is Travis Moore, and I'm here to demonstrate today that Ms. Innocent should not be classified as an enemy combatant because she does not fit underneath the definition laid out underneath the presidential order. There's no direct order from the president. She did not knowingly aid or abet an act of terrorism like my co-counsel Janice has already shown today. And it is also not in the best interest of the United States to hold Ms. Innocent as an enemy combatant. The definition of an enemy combatant is extremely unclear, and at best it is described in the presidential order of the president, where it says, an individual subject to this order shall mean any individual who is not a United States citizen with respect to whom I determine from time to time in writing. The president has not given any sort of letter classifying Ms. Innocent as an enemy combatant. The president, if the president wanted to give this power to another branch like the Department of Justice, he would have specifically put in his direct order from the president to defer this power to the Department of Justice. But instead he says directly that he must sign a letter, so we cannot ignore that fact. Also, it later goes on in the definition to say, the government must have the reason to believe that such individual at the relevant times is or was a member of the organization known as Al-Qaeda. We have no evidence put forward toward this court that show that she's a member of Al-Qaeda or any terrorist ties whatsoever.
Counsel, excuse me, counsel, one way of reading the Hamdi case before us is that we should give very high deference to the government position about whether somebody should be tried in a military tribunal. Do you think we should revisit that rule, and if so, why?
I definitely do believe that we should review this, Your Honor. Mainly because in this case, the government's not even following their own rules that they set forward to try someone as an enemy combatant.
How so?
There's no direct order from the president determining her as an enemy combatant. If we don't have that, then we cannot. That's the first thing it calls for her to be tried as an enemy combatant. Secondly, we have no evidence, reasonable evidence to show that she intended to aid or abet any act of terrorism. And the definition later goes on to say, has aided or abetted or conspired to commit acts of international terrorism or acts in preparation therefore.
Counsel, doesn't conspired, couldn't the defendant in this case have conspired with her boyfriend to commit an act of treason by purchasing the electronic items?
No, Your Honor. Because we have no intent that shows that she did. If we could definitely say that she conspired. We could say the clerk at the store conspired. But if there's no intent shown, then there's no way we can try her as an enemy combatant. This is a very serious role to be defined here, and just because it might look like it is, that she might have at a very slim chance bought these cards for her boyfriend for radical views, there has to be evidence placed upon her. She's going to be locked up in a prison, away from her home, away from her lawyers, and also away from her family. With pretty much no hope in sight, many enemy combatants face years before seeking a military tribunal that you speak of. Also, the definition later on goes to say that it has to be in the best interest of the United States. Miss Innocent is a United States citizen. She was born in Sacramento. She was born in California. She lives in California. She was arrested in her apartment, not on a battlefield like Condi was.
Mr. Ward, let me interrupt before we run out of time. Should we even be having this before the court? And doesn't aren't plenary powers in matters of national security largely within the province of the president? Is this something even for this court to deal with?
It is true that
I'll give you time to finish that answer.
It is true that the executive branch should be given deference to issues involving national security. But when the federal government does not put any evidence, the judicial system, the backbone of this country, cannot roll over when there's no evidence presented against clients who are going to be treated as an enemy combatant.
All right, thank you, Mr. Ward.